Good evening and welcome to Clarkson Wright Jakes webinar on protecting your assets. No further ado, I will now put you into the share screen so I can share the slides with you today. So, our discussion today will be on protecting your assets, and my discussion will be split up into three groups. The first will be on inheritance tax. I will then look at community care and care issues, and finally we'll look at lasting powers of attorney. Dealing first with inheritance tax, basically this is a tax that will arise on an individual's death, and at that point basically your assets are added up, and any amount up to what we call your nil rate band, which stands currently at 325,000, there'll be no tax. But any assets above that will be taxed at 40%. Now, the two main exemptions from that are a surviving spouse and charities. So in the case of a husband and wife, where they leave everything to each other, there will be no inheritance tax on the first death. Of course, when the survivor dies, leaving assets presumed to the children, that's when inheritance tax could arise. And obviously any gifts that you make to a charity will also be exempt from inheritance tax. Now, in terms of lifetime gifts, and this is obviously one of the major ways of mitigating that inheritance tax liability, is to give the assets away whilst you're alive. This tends to fall into two main groups. The first are exempt gifts, exempt from the beginning, and that there are a number of exempt gifts. The one that most people are aware of is the annual exemption, and here basically you can give away up to £3,000 a year, and there will be no inheritance tax liability arising on that. If you haven't utilised last year's exemption, you have that as well, so that is a total of £6,000 that can be given away. Note here that husbands and wives are treated separately, so effectively a husband has £3,000 and a wife has £3,000 that can be given away. And again, ditto if they have not used the previous years, there's that as well to use. Gives us small gifts exemption, any amounts up to £250 will be exempt from tax. Gifts on a marriage, so if you have a child getting married, you can give away an additional £5,000 in addition to your annual exemption. If it's a grandchild, you can give away an additional £2,500. The final one I've got there is gifts out of income. And this often crops up in the kind of the life insurance context, but the concept behind this is that inheritance tax is a tax on capital. And if it can be established that what you're giving away is actually income, therefore, by its very nature, it is exempt from tax. So ultimately, it's a question of showing, what your income and expenditure is over the year. So if you have an individual whose income is that amount, expenditure is that amount, and what you're giving away is that bit in between, then that's gifts out of income. I mentioned that it often arises in a life insurance context. This is one of the simplest ways, if you like, of planning inheritance tax, particularly for younger people, is to take out an insurance policy, a whole of life insurance, paid out on death, and the idea obviously is that money is there to pay the tax bill. Now, obviously, if you do nothing more than that on your death, the insurance money comes into your estate, and therefore the money there designed to save tax ends up being taxed itself, which is a bit pointless. So instead, what we do is we put that policy into a trust, a very simple trust. And usually the insurance companies that provide this cover will also have the kind of off-the-shelf trust that goes with it. So the policy goes into a trust. The trustees would usually be family members. And the idea basically being that when you die, that money is then freed up to pay the tax bill. But of course, if you're funding that insurance policy over your lifetime by way of premiums, the policy is now in a trust. So effectively, you, the settler, are giving those premiums to the trustees to pay the premium. And that will effectively be treated as gifts out of income because it's regular amounts and usually obviously small amounts as well. The third point, I just as a note there, and a note of caution, is that if you make a gift to an individual, you can give what you like away whilst you're alive. Forgive me, I should also have, I'm forgetting the pets first. So after the exempt comes the potentially exempt transfers. And for that, basically, you have to survive for a period of 7 years for the gift to work. If you don't survive, obviously the asset gets clawed back into your estate. So like I was saying, if you make a gift to an individual, you can give what you like away in your lifetime. But if you're setting up a trust or putting the money into a trust, then you do have a limit of £325,000. And if you put more than that into the trust, there will be an immediate inheritance tax liability at 20%. So it's just something to be aware of. It often crops up when individuals are giving away property and services, second properties. When we have this discussion with clients, it's usually they've got a second property, often a rental property, and they're now thinking, oh, right, we need to pass this asset down to the next generation, otherwise there'll be a big inheritance tax bill. But of course, if the value of the property itself is more than 325,000, there will be a tax bill if it goes into a trust. So just be aware of that. The next slide really covers the issue between capital gains tax and inheritance tax, and really follows on from the discussion I just raised about the concept of giving the asset away, in the example here of a second property, because there are actually two taxes to be aware of here. First is inheritance tax, and for that to be, as we've said, you have to survive for 7 years for that for the property to fall outside of your estate. But the other, rather more immediate tax to be concerned about is capital gains tax. And here, basically, if you give away certain assets, here a second property would be a classic example of it, there will be an immediate capital gains tax liability, and that will be calculated by looking at the value of the asset you're giving away, less what you actually paid for it, the acquisition cost. You have your annual exemption for CGT, which I think is 12,300 now, and then the balance effectively is taxed either at 18 or 28% based, 18 or 28% based on your sort of income tax rates. So that can be quite a rather unpleasant sting in the tail for any tax planning, particularly as you're giving the asset away to the children. Therefore, you're not actually physically selling the property, but you still have to come up with the tax regardless. So one way around this is to gift the property into a trust rather than direct to the individual. If you give it into a trust, you have this thing called holdover relief, whereby effectively you can defer that capital gains tax liability to a point where the property is subsequently sold. So it doesn't avoid the tax liability, but it defers it. So you can make the election on the property going into the trust, let the property stay in the trust for a year or so, then transfer the property out of the trust to the children. Again, an election for holdover relief will apply. So effectively what you've done is you've got the property from your ownership to the children's ownership without there being any tax liability. But when they subsequently come to sell the house or the property down the line, the acquisition cost will be your acquisition cost, not what the value was when they acquired it. So the tax will come, but it will come at a point when the house is being sold, and therefore you have the funds to pay for it. So well worth looking at, but again, just bear in mind capital gains tax and inheritance tax. So if you're putting the property into a trust, bear in mind the value of the property. If it's more than 325,000, there will be a potential immediate inheritance tax liability on 20% on the excess. So it's weighing up those two taxes and working out what is best for you. So moving on. What I want to do now is look at 3 different scenarios, and hopefully anyone listening to this, you will fall into one of these categories. The first is a married couple. We'll call this couple Mr. and Mrs. Osborne. Basically, we have Ozzy and Sharon with assets of 350,000 each, and we'll assume that they made very simple wills, leaving everything to each other. And we'll also assume that Ozzy goes first. And I apologise for any gentlemen listening to this webinar. You'll note as we go through this that the gentleman always tends to go first in my examples. I'm not being discriminatory. It is just the statistical fact that we don't live as long as the ladies. So Aussie goes first. Everything passes to Sharon. At that stage, there is the surviving spouse exemption. So there's no inheritance tax at that point. When Sharon comes to die, her estate will be now 700,000. In other words, the 350 that she had aggregated with the 350 that she's inherited from her husband. Now, what happens at this juncture is we take into account her nil rate band, 325,000. But we've also got this thing called a transferable nil rate band. Now, this came into being back in 2007. It was a creation of Alistair Darling, who was the Chancellor at that time. But basically, when you're dealing with a married couple or a civil partner, then you not only get the nil rate band, you also get your deceased spouse's nil rate band as well. So it's quite a generous allowance. It was generous at the time, but of course, a couple of years later, the government froze the nil rate band at 325,000. So it always, with governments, there's always they'll always get their take at the end of the day. But basically here you've got the 325 plus 325, that's 650. You take that away from the 700,000 and you are left with £50,000, which is taxed at 40%. So that leaves you at least a tax bill when Sharon dies of £20,000. We will come on in a short while to look at what we call the residential nil rate band. It's an additional allowance that will apply here, but I want to really do this sort of step by step so you kind of understand the concept involved. So that's the first couple, a married couple. The second is a couple who are unmarried, and I have to be honest, in terms of inheritance tax, this is the sort of couple that gets hit all the time, and we'll see exactly how in a second. But it's certainly worth bearing in mind, if you're unmarried, there can be a really big inheritance tax cost down the line. So here we have a situation of Kurt and Goldie, unmarried, same figures as the previous slide, 350,000 each. But what's happened here is, or two issues. Namely, first of all, because they're not married, you don't get the spouse exemption. So on Kurt's first death, there will be an immediate inheritance tax of £10,000. Okay. His net estate, which is 340,000, now passes to Goldie, and when she dies, we don't have the transferable nil rate band. So it's a double whammy here. On her death, her estate now is worth 690. We take away her nil rate band of 325,000. Tax at the balance means there is a £146,000 tax bill at the end of the day here. So quite a sizable tax bill. Now, the question has to be asked is, what can we do about that? And the most obvious answer is for Kurt and Goldie to go off and get married. And I have to say that over the years, I have pretty much married off quite a number of my clients, yet to be invited to the wedding, but I always hold out hope on that one. So that would be certainly one option. But it may be that you're the kind of couple that feels actually that you would like to get married maybe for more romantic reasons than the need to obtain the transferable residential nil rate band and the spouse exemption. So for that reason, basically there is an alternative, and that is the use of wills, and to be precise, the use of a thing called a discretionary trust. Before I look at this in more detail, just to point out to you that this particular type of trust, which we've used for many years now, not only works well for an unmarried couple, but it also works well if you're a couple owning business assets. And also, which is a slightly quirky kind of arrangement, if you're in a situation where one of you as a spouse was previously married to your previous spouse, and that individual left their estate to you on their death, absolutely. And in that scenario, if you set up a discretionary trust in your will here, there is the potential that you could actually have 3 nil rate bands, or even 4 nil rate bands when the survivor of you dies. So it's actually quite it's got a quirky situation. But if you do fall into this category, then please, by all means, contact me after you've seen this. We can talk about it in more detail. But I've given an example what I'm trying to say there on the slides. So hopefully that will make sense. So without any more ado, let's look at how the discretionary trust works. Now, what you need to appreciate here is that what we're trying to achieve here is or stopping that aggregation that would arise on first death, where the assets pass to the survivor. It doesn't stop the inheritance tax arising on first death. So in this situation where Kurt dies, the 350,000 that he has at that stage, there will be a tax bill on that, and that will be at £10,000. But instead of the balance of his estate, about 340, passing to Goldie, which is then added to her estate on her later death, what happens is that goes into this thing called a discretionary trust. Now, how this trust works, basically you start off with Kurt appointing executors and trustees in his will. That basically would be a minimum of 2 or a maximum, up to a maximum of 4 individuals. And I would most definitely recommend Goldie as one of those trustees. The others can be children, it could be a good friend, it could be a professional. The choice is yours. Often I don't recommend the children simply because there could be kind of conflicts that could crop up there, but ultimately it is the client's decision. The beneficiaries of the trust basically will be Goldie, the children, grandchildren, anyone he cares to mention, and will be named in his will. And the point being that no one beneficiary is entitled to anything without the trustees say so. So in practice, basically what will happen is that Goldie, along with the other trustee, will effectively give assets over to Goldie. If there's a property involved, then Goldie can carry on living in the trust share of it. So, but the crucial point here is those assets do not belong to Goldie. So when she dies, her estate is the 350,000 and not the combination of 350 and 340. So on her death, she has her nil rate band of 325, and there is a tax bill then of an additional 10,000. And you can see here that actually the tax bill now effectively equates to the same as a married couple. Although with a married couple, it's 20,000 paid on the death of the survivor. With an unmarried couple involving discretionary will trusts, you've effectively got a tax bill on first death and a tax bill on second death, equating to the same amount. So that is certainly a good way of mitigating inheritance tax when you are an unmarried couple. The only slight sting in the tail here is that with regards to the discretionary trust that was created on Kurt's death, every 10 years from Kurt's death to Goldie's death, there would be an inheritance tax liability on that amount. But this is a much smaller amount that would otherwise be the case. Effectively, every 10-year anniversary, we take a value of the trust fund at that time, we deduct the nil rate band of 325,000, and the balance is taxed at 6%. So you'll appreciate it'll take a lot of 10-yearly 6% to get anywhere near the 40% tax charge that would otherwise be the case. So it is a slight cost that has to be factored in, but it is a small cost in the grand scheme of things. So that's the second group of individuals. The third is the unmarried couple. In this case, it's Nigella. At this point, my heart just skips a beat, but good old Nigella there. Basically, the divorcee stroke spinster. Sadly, there is no transferable nil rate band available for Nigella, and there's no ability really to use will planning here either. So really for individuals like this, really your choices are looking at pets, potentially exempt transfers, gifts, that sort of thing to mitigate the inheritance tax liability. So moving on, as I mentioned earlier, the residential nil rate ban. Now this was a creation of George Osborne. The politics behind this was effectively a few years ago, the Tories had made a promise to provide £1 million nil rate ban. £1 million would be given away without there being a tax liability. They made the promise, and then I think the next government was a coalition government with David Cameron, and the Liberals were not in agreement with this at all. So that was kind of put on the back burner. Then a few years later, Mr. Cameron won a surprise election without the need to call on the Liberals. So of course he was then left with having to come up with this, to make good on the earlier promise. And George Osborne came up with this rather convoluted arrangement called the residential nil rate ban. to be honest, what he could have done is to have said, well, actually, we have frozen the nil rate band since 2009. Let's unfreeze it and let's give it a value of £500,000. And with married couples, the two lots of £500,000 would make £1 million. That would have been the easy option. George Osborne, forgive me, I always say switch the mobile phone off. George Osborne was like to make things more complicated. He came up with this arrangement whereby it was an allowance that was made available to certain individuals. Effectively, if you owned your own residence and if you had lineal descendants, whether it was children or grandchildren, and if you fell into those two categories, then potentially you would have an additional allowance. This was the figure of 175,000, which, with the case of a husband and wife, would be doubled up. So on the death of the survivor, you would have the residential no rate band of 175 plus the deceased transferable residential no rate band. So effectively, it would make a total of 350,000. And if you added that together with the 650 that you get from the transferable no rate band, you get the £1 million allowance. So that was that. The problem, however, with that was, what about those individuals who were renting property? Well, they didn't get that additional allowance. What happened to those individuals who don't have children? Well, they don't get that additional allowance. I mean, quite why they were being prejudiced by this, speak to George, I guess. And there are also some rather interesting little catches when dealing with this particular allowance that you need to be aware of. So, for example, if you were leaving a share of your estate to grandchildren on your death, and you were to specify an age for them to take, which would be the sensible thing to do, say 21 or 25, you potentially would lose a share of the residential no rate band. Whereas if you were to give it to a grandchild with no age stipulation, in my view, acting recklessly, then the government encourages you to do that. So that's a bit of an odd one. George also took the view that if you have an estate worth 2 million or above, you are deemed as rich and therefore not entitled to the residential no rate band. So something to be aware of, particularly for those of us who live in the southeast, where property prices can quite easily take you up into those sort of figures. And the third point to note here is if you leave a share of your estate in a discretionary trust, so that could be maybe for maybe one of your children has financial difficulties and you wanted to put their share into a trust to protect them, or maybe one of your children has matrimonial issues and you wanted to put that into a trust to protect in that situation, then potentially you could end up losing a share of the residential no rate band. So some really quirky, odd loopholes there. So I think my advice to everyone is that if you've had your will done a number of years ago, always worthwhile to get it looked over again by a solicitor, just to make sure that that you're ticking all the right boxes as far as that additional allowance is concerned. I mentioned this particular slide. This really kind of covers the couple who have estates over 2 million. And one thing that can be done here, particularly if your estate is just bordering, is what happens basically is if your estate goes above 2 million, there is what we call taper, and basically that the allowance is gradually removed, so that when you get to 2.25 million, effectively you have no residential and transferable residential no rate band available. And so what you're looking at really potentially is losing £140,000 of tax here. So it's well worth looking at. Now, one way of kind of protecting that allowance is looking at some will planning here. So to try and explain what I'm saying, if you have a couple, let's say husband has, let's say, £1 million in his name and the wife has £1 million in hers, instead of doing simple wills leaving everything to each other, so husband dies first, leaving his £1 million to his wife, so when she dies, her estate is 2 million, and in which case we now have a problem for the residential. What we do instead is we create this thing called a discretionary will trust on first death, rather like what we talked about with regards to Kurt and Goldie a little little earlier. So effectively what happens is that on first death, 325,000 is peeled away from the husband's estate, and that's put into a trust, of which the widow has access to, but it doesn't belong to the widow. So ultimately, when she later comes to die, instead of an estate of 2 million, it's 2 million minus 325,000, which was in that earlier trust. So what we've got here is the availability of the residential no rate ban. So for anybody whose estates are kind of around the 2 million or a little bit above it, well worth coming along, having a chat with regards to just doing some very simple will planning that will get you back on track with regards to that residential no rate ban. So you're seeing sort of from what I've been talking so far that one of the simplest ways of mitigating inheritance tax is to start looking at giving assets away. We talked about annual exemptions. We talked about potentially exempt transfers. But the sting on the tail in this one is that if you give too much away, where does that leave you as far as care is concerned? And that's often when I'm having a conversation with clients, it's the elephant in the room. It's okay, fine, I give all this money away, but where does that leave me if I need to go into residential or nursing care in the winter years of my life? And what sort of care am I gonna have? While the children are swanning off in Marbella with my hard-earned assets. And it's something to be aware of. And what we need to do now is look at community care, both in the context of protecting assets for care, but also in a sense, knowing that if we can get assets protected from a care perspective, it then kind of frees you up with more flexibility in terms of inheritance tax planning as well. So in a nutshell, what happens with long-term care is if you need care, your capital effectively is used. We'll look at it more in detail in a second, but ultimately your capital dwindles down to a figure of 23,250, when at that point the local authority becomes involved. But it's only at 14,250 when effectively the local authority will take over the funding of your care. So there can be it can have a serious impact on your assets. So what we need to do now is say look at care plan wills that will protect that. But before we do that, just to sort of sum up where we are so far, inheritance tax basically we've seen as being a 40% tax on capital over 325,000. You've got the transferable no rate ban as well, so that would take you up to 650,000. And on top of that, potentially you've got the residential no rate bans as well. So for some people, you have a £1 million no rate ban, others you don't. But community care basically is 100% tax on capital over 23,250. So let's look at that in a little bit more detail. And as I was saying earlier, effectively, if you have somebody who needs to go into care, their income will go first, undoubtedly. But usually the income is not enough to fund that care. The cost of care these days, £1,500 to £2,000 a week. Not many people have that amount of income. So what will happen is your capital will be used, and that will be bled down to initially 23,250, when the local authority will start to contribute. We get involved in this thing called tariff income at that point. So it's a kind of a formula basically designed to ensure that the resident pays part and the local authority pays part at that juncture. But your capital further dwindles down. It gets down to 14,250 when basically the local authority take over completely. So that's really what we need to look at in more detail here. And what we're going to do is look at a couple here. Mr. and Mrs. Smith, they've got a property in their joint names worth 300,000, and they've got savings of 50,000 each. And basically, in terms of income, Mr. Smith has a state pension of £250 a month, private pension of 400, and interest on savings of another 100. So they've been living off their income, maybe calling on the capital, a little bit of capital to maybe pay for holidays or fix roofs, that sort of thing. When Mr. Smith starts to show some sort of signs of forgetfulness, and they go down to the GP, tests are carried out, and the test comes back to confirm that basically Mr. Smith has early stage dementia. And Mr. Smith will now effectively, Mrs. Smith will now effectively become his carer, and as his condition deteriorates, she'll become more and more his carer when the time comes where we need to look at putting Mr. Smith into to care. Basically, Mrs. Smith can no longer look after him in the home. Well, the first thing that will happen is there will be a needs assessment to be carried out on Mr. Smith to find out whether he actually physically needs long-term care, or whether we could be looking at perhaps some domiciliary care instead. If the conclusion is he needs to go into a care home, then the million-dollar question: who pays for it? And that is usually carried out, seen through a financial assessment. And in this case, we'll assume the care cost comes in at £4,000 a month. His income goes first. So state pension interest on savings is used. Any private pension he gets is split. Half of that goes on the care, the other half Mrs. Smith gets to keep. There will be attendance allowance available here. So we add that to the mix. So we've got a total of 750, but there's a shortfall here of 3,250. So who pays that? Well, if you go back a couple of slides, it'll come from Mr. Smith's cash. So that 50,000 will then bleed down to 23,250 when the local authority will start to contribute, but and obviously ultimately down to 14,250 when they take over. Now, question stems from that is what happens, first of all, what happens to the house, and secondly, what happens to Mrs. Smith's assets. Now, dealing with the house first, the good news here is at this particular juncture, the property is safe. It is safe basically because Mrs. Smith continues to live in the house, so it's disregarded. Note, if she ever decides she wants to downsize, she can do so. Basically, as long as the local authority is aware of what's going on, there's no reason why she can't downsize, but obviously any property that is purchased would then have to be purchased in the names of her and her husband, assuming obviously the property was owned by them jointly. The other thing to note here is that downsizing is often done to release funds because the spouse who's not in care is needing money. You need to be aware that on any downsizing, any profit made from that downsizing, half belongs to Mr. Smith and will be lost on the care. The other half, Mrs. Smith's half, she'll obviously get to keep. But just be aware that there is an issue there. The other point, I suppose, is what happens to Mrs. Smith's assets. In other words, is there a way in which the local authority can get their hands on her capital? And the simple answer to that is they can't. It's her own money that remains disregarded. Obviously, it then boils down to what Mrs. Smith chooses in terms of care for her husband. Often I find when in this sort of situation, because of the lack of choice for local authority care homes, it's usually a private home which requires a voluntary third-party top-up. So when I say that there's no way the local authority can get their hands on Mrs. Smith's assets, well, in practice, very often they do in that scenario. So the next slide, we're going to look at a situation which you wouldn't think would happen, but it can happen, and it happens, dare I say, quite often. And the situation here is where it's the spouse who isn't in care actually dies first. Because obviously dementia, being a very long-term illness, can last for a number of years. But in this situation, what's happened is Mrs. Smith has passed away before her husband. And there are a couple of assumptions I'm going to put here. The first assumption is that they own the property as joint tenants. More about that in a second. And the second assumption is that they made very simple wills, leaving everything to each other. Okay. Now, in terms of the property, there are two ways in which you can own the property jointly. The first is as joint tenants, which basically means that when one party dies, the half share goes automatically to the survivor, irrespective of what's said in the will. The other is as tenants in common. And that means basically whoever goes first, their share goes in accordance with their will, whatever that says. Now, most people own as joint tenants. Tenants in common is usually when there is wills in place for tax or for care planning reasons. More about that in a second. But some people, unfortunately, they read articles in the newspaper and they see that they get the impression that just serving the joint tenancy on its own will work and will somehow save money. It doesn't, and actually can be very dangerous if you do it without, getting proper legal advice and getting the correct will in the background. So in this situation, they own as joint tenants. She's died. Her half share now passes to Mr. Smith, and of course, any cash assets that she's left passes to him through the will. So the net result of that is his capital now rockets above the 14,250 and the 23,250 threshold. And then we start the whole sorry saga all over again, where his capital is bled down to 23,250, down to 14,250, when on his death, that's all that is left. And if you ever wondered why you have this 14,250 threshold, I suspect it's simply so that you have enough money to be buried at the end of the day, or cremated. And all I can say on that is that the powers that be really feels that you should be entitled to have a damn good burial, because you can 14,250 can go a long way in that regard. So that's the situation there. I guess one simple thing that could have been done that would have mitigated at least half of those assets would have been to make Mrs. Smith to make a new will. Because ultimately, by leaving everything to her husband, effectively, she's leaving everything to Kent County Council Social Services Department. What she should have done is to have made a will, usually in this sort of situation, leaving her share direct to the children, or she can set up a trust for her husband to make sure that he's provided for, but ultimately her capital isn't used for the general assessment purposes, maybe just there for voluntary third-party top-ups, that sort of thing. Plus, doing the will, she also needs to sever the joint tenancy of the house, because no point making a new will if the biggest asset goes automatically to the survivor. So, as well as the new will, she severs the ownership of the house so they own as tenants in common. And that can be done. Mr. Smith has to be notified of it. He may not understand what is going on because of his condition. That doesn't matter. He's notified. It affects the notice of severance. They own as tenants in common. If she then dies, her half of the house and her savings are therefore protected for the children. So a very simple way that would have protected those assets in that scenario. So what I'm going to do now that we've seen the problems that can arise with care, we're going to look at two situations where you can actually ring fence those assets. The first is basically through some planning, usually involving the property and involving effectively giving the property away. And to demonstrate what we're talking about here, we're going to look at this lady called Mrs. Bloggs. Now, Mrs. Bloggs is, if we put it in context, she's a widow. Husband had died a few years earlier. He had left everything to her, so there's been no planning historically. She owns the house outright. She's got a couple of children, getting on in years, and she's seeing a number of her friends going into care, and is concerned that that property will find its way to the right people, i.e. the children. So what can she do about it? Well, I suppose the simple answer to that is to say, well, why doesn't she just give the property to the children? And when I ask that question to clients and say, okay, what is your response to that? They'll say, oh, we've heard about this 7-year rule. And I have to answer them on that basis that they're wrong. The 7-year rule is completely irrelevant here. The 7-year rule only applies to inheritance tax. And in any event, this kind of arrangement for tax purposes wouldn't work anyway. But for care, there is only one rule, and that is what we call the predominant reason rule. Effectively, Mrs. Bloggs makes the gift of the property to the children, and then subsequently, down the line, goes into care. The local authority will look very closely at that gift. And if they can establish that the predominant reason behind that gift was the avoidance of the funding of care, then they'll bring the property back into Mrs. Bloggs' estate for care funding purposes. So this really boils down to looking at the background circumstances. In other words, effectively, the state of health of Mrs. Bloggs when she made the gift, and the length of time between her going to her making the gift and her going to care. So a very healthy, sprightly Mrs. Bloggs making the gift and going to care, say, 10 years later, will be in a much better position than a very frail Mrs. Bloggs making the gift and going to care, say, 7 or 8 months later. So it all boils down to the individual circumstances. Regardless of that, I would never, ever recommend a straight gift to the children. I think that is extremely dangerous. And the risk involved here is basically, well, first of all, what happens if one of the children falls out with mum? This is the roof over her own head, and she could be in difficulties. Secondly, what happens if one of the children should get divorced or have financial difficulties? All of a sudden, their continued occupancy is very much reliant on an ex or creditors. The third, what happens if one of the children should die before her? Have they provided in their own will that mum has the continued right to occupy the property that they now own? And I guess the final point is, if none of that applies, when Mrs. Bloggs later comes to sell the property, of course she won't be selling it, it will be the children. unless they're living with her, there will be a potential capital gains tax liability because it's not their main residence. So a stray gift to the children is fraught with difficulties, and it's something I would recommend. However, what she can do is give the property into a trust, what we call in the business a property trust. Effectively, what happens, this takes place in her lifetime. This is not in her will, but in her lifetime, Mrs. Bloggs sets up a trust. She will be a trustee along with, a third party. Now, that picture there, it could either be her son, it could be a good friend, it could be her solicitor. The choice is yours. But the trust basically provides that Mrs. Bloggs has the right to live in that property for her lifetime. So no one can kick her out the house. Any problems with, bankruptcy of the children, divorce or fallouts, she's fine. She's safe there. She can downsize if she wants to do so. So there's that flexibility as well. And basically on her death, the trust comes to an end and the property will then revert back to the children in accordance with her will. So basically what we're doing is we're getting all the benefits with none of the risks. You're getting the property out of her hands, but ultimately protecting her at the same time. Now, a couple of points to note here. First of all, the predominant reason rule still applies. So it boils down to looking at the background circumstances with regards to setting up the trust. And that really is a kind of conversation between myself and the client when we set the scheme up in the first place. The second point to note, do you remember the conversation I had a little earlier about the inheritance tax and the amount you can give away without there being a tax liability? Now, although we're not doing this for inheritance tax reasons, if the value of this property is more than 325,000, there will be an immediate inheritance tax liability of 20% on the excess, regardless. And that can be quite a penal tax to pay here for something that you're not even doing to save tax on. So what you do about it, some clients I've known have actually done, said, okay, we'll pay the tax, don't care. Our primary concern is the kind of the care issue. But for others, what we've done is we've given a proportion of the property away into the trust, equating to that nil rate band. And the remainder stays, in this case, in Mrs. Bloggs' sole name. So ultimately, she then needs to go into care. It's only her little bit that is attacked, but the bulk is in that trust and protected. So that is a property trust and well worth looking at, particularly for those individuals that have made no planning. It's usually a situation where it's a widow or a widower. There's been no will planning previously, and we're now looking at getting the asset away for care purposes. The second thing to look at is your wills. And in a sense here, what I'm saying here is that if you have a situation where, let's say, a husband and wife, and they make wills leaving everything to each other, again, if one party dies, let's say the husband goes first, wife then goes into care, then basically everything is up for grabs, including what she's inherited from her husband. So a very simple first step in terms of protecting assets is to take the husband's assets here, which would be the cash and his half share of the house, and put that into a life interest trust in his will. So effectively what it means is that Mrs. Smith, in this example, carries on living in her share of the property, and as a beneficiary under her husband's trust. She has access to his cash, but ultimately if she then needs to go into care, it's only her half of the house and any cash she has that will be attacked and not her husband's. So a really good way of effectively ring fencing a half of the assets here. Note they need to own as tenants in common for this to work, but again, it's something that we would do as part of the whole procedures of drawing up wills. And also note here that once we've done those wills and when one party has died, at that stage, what we often do is we look at the survivor's half of the house, and that we then take that half and put it into the property trust that we just talked about earlier. So ultimately, what will happen is that if Mrs. Smith now needs to go into care, potentially the entire property is ring-fenced. Her husband's most definitely ring-fenced. Hers more speculative and boils down to the issue of predominant reason. But if we get over that, you've got the whole house protected. Now, also with regards to the wills, predominant reason has no relevance. So in other words, if we have a situation where Mr. Smith dies on day one and Mrs. Smith goes into care on day two, the wills are safe. It's completely protected. So that's certainly the very first step I would say in terms of protecting assets for care. So that's community care. The last subject today I want to talk about is powers of attorney, a very, very important subject indeed, and is often kind of forgotten about in the grand scheme of things. It covers the, dare I say, the kind of gaga scenario. You know, you become mentally incapacitated for whatever reason. Who manages your affairs at that stage? The first point to note is that your will doesn't apply. You're still alive. You may not be able to manage your affairs, but you're still alive. Spouses and children have no magical powers here. So ultimately, unless you've done what we term a lasting power of attorney, the default is a thing called deputyship, which is a court-appointed individual through the Court of Protection in London. And frankly, I wouldn't wish that on my worst enemy. It is a very complicated, expensive process, and it takes a lifetime. If pre-COVID, it was taking a lifetime. Now, it takes a while to get sorted out. So what you do instead is you prepare a lasting power of attorney. And these take actually two forms: finance, dealing with your financial affairs. We've also got these things called welfare lasting powers of attorney, and they're becoming increasingly important. And they deal with welfare issues, so things like decisions over life-sustaining treatment, complaints over medical treatment, where you live, who you live with, should you become mentally incapacitated. Now, without that, basically decisions over your welfare will often be made by healthcare professionals should you become incapacitated. And they will be making decisions of what they perceive to be your best interest, but that may not be what you and what the family see as best interest. So my advice to everyone is to get both a finance and a welfare lasting power of attorney done together. So the two will interlink and will work. Now, the advantages of certainly the finance LPA over deputyship is it's much easier to set up and much easier to administer. Now, in terms of setting up these things, they can be done online. The Office of the Public Guardian have a digital tool that enables you to do this online. Personally, I think doing these sort of things, it's rather like doing a homemade will, and there are risks involved there. I think that there's a lot to be said for getting this thing done correctly at the beginning. And then basically, once that's done, you'll find that the whole process is seamless moving into the future. So in terms of the powers of attorney, the first thing you need to be thinking about is who you have as your attorney. And in this scenario, my suggestion would be to have, in the case of a married couple, you would have each other, the other spouse, as the respective attorney, but don't leave it there. Have somebody else in place, because if, God forbid, there is, I don't know, a car crash, let's say one of you dies, the other one is now in a vegetative state. If you've just had each other, then the document is worthless. So what you would do, my advice would be to have replacement attorneys, and that would be usually be the children, say of the spouse as the primary, children or others as the replacements. Single individuals, you normally have a good friend or a family member as your attorney. Some of my clients think of nobody. We can have professional attorneys, myself, my colleague. It's not something I'd recommend, because I'd much prefer for you to have a family member or someone that knows you making those decisions. But if that is impossible, it is a service we provide. If you have more than one individual, that's usually where you're dealing with the children. They can either act jointly, in which case they've all got to act together, or jointly and severally. Now, jointly, it gives a bit more security, because no one person can go off on a whim. But the danger with that approach is if one of the attorneys dies, one of the children dies, then the document is null and void. Or if one of them moves abroad, it can, moves away from the area, it can be quite difficult to manage. Personally, I prefer the joint and several route, which is any one or more of the attorneys. It's a much better way of doing it. And certainly, if we're dealing with happy families, there's no issues within the family, a joint and several approach is great. And if you've got issues in the family, you probably don't want to be having them as attorneys in the first place. So joint and several is one I would recommend. Other couple points to note here, the certification procedure. One of the part of the process of preparing the lasting power of attorney is you need to have this thing called a certificate provider, who is somebody who will certify that you know what you're doing and you had the right capacity and no one's putting any pressure on you when you sign the document. Now, that would either be what we call a knowledge-based provider, and that's basically a good friend, somebody who's known you for at least 2 years, or a skills provider. That would be either a doctor or a lawyer. And usually with the clients we do, we're preparing these documents for clients, we will be the certificate provider. Obviously, no additional cost. It's all part of the service. The other point to note here is the registration procedure. Now, I haven't mentioned yet the old enduring powers of attorney. Now, if there's anybody here listening who's done an enduring power of attorney, these are completely fine. They were the documents that were being prepared before lasting powers of attorney came into being. So lasting powers of attorney came in October 2007. And before that, we had these enduring powers of attorney. If you've got an enduring power of attorney, then as long as what it says is still you're still happy with, then classic case of if it ain't broke, don't fix. So that's fine. But from October onwards, you couldn't do an enduring power of attorney. We're now left with lasting powers of attorney. I would also just briefly note that if you've done an enduring power of attorney, that only deals with financial affairs. It doesn't cover welfare. So my advice here would be get a welfare lasting power of attorney done as well. So you've got it working that way. Now, I mention this simply because with the registration procedure, it's slightly different depending on if it's an enduring power or it's a lasting power. With an enduring power, it's all about person's capacity, and the document only needs to be registered once the person has become mentally incapacitated. So if we take the example we were using earlier of Mrs. Bloggs, and let's say she's got a couple of children and they are her attorneys under an enduring power of attorney, and let's say she has a minor stroke, so basically struggling a bit physically, but mentally she's still fine. She can give that enduring power of attorney to the children and they can crack on and deal with her affairs. If she then has a major stroke, becomes mentally incapacitated, at that stage and at that stage only does the enduring power of attorney need to be registered. Now, if it was a lasting power of attorney we're dealing with, basically it's a very distinct two-stage process. Ultimately, the first stage is the preparation of the document. The second stage is the registration, and nothing can be done, nothing can be acted on without that document being registered. So if we take the example of Mrs. Bloggs, who's done a lasting power of attorney, but she hasn't registered it, and she then has that minor stroke, then the document needs to be registered for it to be activated, for it to be used. Do you see what I mean? It's not based on her capacity. Now, for that reason, most of my clients will, once we've prepared the document, we'll get it registered at the same time. The logic being that once it's registered, it's ready to go. Registration tends to take between 2 to 3 months, taking a bit longer now because of COVID. It's registration with the Office of the Public Guardian. But once it's registered, it's ready to go. So in that scenario of a minor or major stroke, it reacts on like that. So I would always recommend, if budgets allow, to get that document registered immediately. The problem is, it's an expensive process. And to get it registered, we charge a little bit extra. We'll look at our fees in a short while. But you have to factor in the court fee, which is £82 per application. So for the case of a husband and wife registering finance and welfare, that's 4 documents totaling £328. So it can get expensive. So for some people, we will leave the documents unregistered on the basis that at least it's better than deputyship, but the clients know that effectively it's a job half done, and it then needs to be registered if anything happens down the line. So my stock advice is, if you can afford it, get it registered, but don't have the court fee putting you off doing the document in the first place. Do not rely on deputyship. It's not the way to go forward. So as I put in there in the note there which to choose, it really boils down to individual preference and budgets. So on the subject, I mentioned costs, just to flag up how the costs work with CWJ. A lot of our work in our private client department is very much based on fixed fee. If it's a simple will, so husband and wife leaves everything to each other, or a simple single will for a single individual, our fees are £290 plus VAT for a single will, £400 plus VAT for a couple. Our next stage is the estate planning service, which really pretty much covers the Mr. and Mrs. Smith situation of doing the wills designed to protect the care. Single person, that could be setting up a trust. Perhaps they've got a child with learning difficulties or something, or one of the children got divorce issues and they're doing a trust there. So for a single person, you're looking for 60 plus VAT. For a married couple, you're looking £800 plus VAT. This is all in, by the way, not each individual will. And the advisory service, the third level, basically this kind of covers I would say if you're business owners, or let's say the Kurt and Goldie scenario earlier with the discretionary trust, that tends to be worked on an hourly rate, and that ranges from 135 to 325 pounds per hour, depending on the obviously the law that is instructed. And the final one there, the trust on the property. If you've got a doing the, if you like, the Mrs. Bloggs trust, you're looking at a flat fee of £1,600 for that. The next slide, slightly more busy slide. This just kind of covers the powers of attorney and the different scenarios. So it can range from a single person doing one document unregistered to a couple doing all 4 documents and registering them. And I've kind of included all the fees in that. Also note, if you are registering the documents, you have to add the court fee of £82 to each of those documents. So that pretty much finishes the talk. Before I go, just some useful notes that I always mention to clients. The first thing is my advice always with these talks is to use a solicitor. We'd love to see you at CWJ. If you're interested in what I've had to say, please contact us, and we'll have you in for a meeting and we can talk it through. But the one thing I want you to take away from this this talk is the importance of using a solicitor. You are buying effectively our expertise and experience. And if anything goes wrong, we are insured. There are out there sort of will writers who are not regulated. Some are good, but some aren't. And the trouble is, you as the client don't know that. And the only time you're ever going to know it, ultimately, potentially, is when you die, when the will is looked at and we realise there's all sorts of problems there. So my advice is always speak to a solicitor. And other way of selling ourselves to talk about if anything goes wrong, but we're all human. But as a solicitor, we have to be insured to cover that situation. 2 organisations to be aware of: STEP, which stands for the Society of Trust and Estates Practitioners. Very, very useful organisation. Check if the person you're speaking to is a member of that. Also, there's a group called the Solicitors for the Elderly. Again, if you're a member of that, then usually the person knows what they're talking about. And beware of alternatives. If you see adverts referring to legal services, but it doesn't use the word solicitor, they're not a solicitor. So be careful. Will writers, insurance salesmen, they're all at it, and the idea obviously is to flog you basically usually a rubbishy will on the basis they can flog you some life insurance or other cover. Just be very, very careful. There are a lot of people out there that will rip you off, basically. And my advice is get the right advice and don't be one of those people that gets ripped off. And it even follows into the bereavement services. We've come across an organisation called the Bereavement Advice organisation. Their sole purpose, although you would think bereavement advice, it was about giving you bereavement advice, it's about flogging probate off the back of a well-known supermarket. So just be very, very careful with who you talk to, and just make sure you speak to a solicitor. So ultimately, I think, just to conclude, consider what impact inheritance tax and community care have on your savings. Need be, take a fresh look at your will and make a lasting power of attorney whilst you've got the capacity. Don't do what some people I've heard comments say, well, they'll leave doing that until they're gaga, which defies the object because you can't prepare it at that stage. So get your affairs in order. As I say, more than happy to talk to you at CWJ. I hope you found today's talk helpful. And if we normally run these as a webinar. Today's has been a recorded one, but often we run them as live webinars, and hopefully soon we will be able to start giving seminars again to clients. So watch this space on that. So I hope you have enjoyed today's talk, and thank you very much indeed. Hopefully we'll see you at CWJ in due course. Many thanks. Bye-bye for now.